Hey guys, welcome back to my channel, WHENTAYTALK. I am Tay, and I am here for a segment of Here We Go with the Bush. Y'all, here we go with the bush. Cookie want to say hi because there's some mess going on. Can you talk to them and not me? Okay. And she said all she had to say. Okay, and that's on P. So, y'all, we need to get into the shits. Okay. Now, everything on the channel is alleged in my opinion and for entertainment purposes only. Okay, please like this video. Subscribe to this channel because y'all know we over here on WHENTAYTALK 2 because WHENTAYTALK 1, the original, is on damn restrictions. Okay. Okay, YouTube said we ain't forgot about you, back. Okay. But I digress. Don't worry about it. Just make sure y'all subscribe over here too, okay? Because they on that budget. The mass reporting about it all, okay? The legalities of it all, YouTube. So let's just mind our business over here on this channel, okay? For a little while, okay? But I digress. Let's move on. So we are here to talk about these court cases. Oh, yes. Martell and Benny. Let's go on and get Martell out the way first because I think this motherfucker kind of got what he wanted in the Kirk case. Pitiful batch. So y'all got to go over to T from TV. She have those court documents. Y'all know Martell and his ex-wife was in a heated custody battle for quite some time. This shit been going on for a while. When she treated him to the little trip in Dustin, it's been on and popping every damn since. Okay, but it came to our attention that he had requested a continuation of the court. Now, mind you, this case been continuation because him and the ex-wife was also in a harassing communication damn case that his ass pled guilty to again. Okay, so that was over last month. So now they can go ahead and proceed with the child custody case because they were extending it until the final results came from the criminal case that Martell had open. So this bum ass motherfucker tried to put in a request for a continuation because he wanted to go and film the reunion. I think this was last week or something like that. But you ain't know that this case was coming up and that the reunion, when the reunion was. Now, we know that y'all be on the fly with Carlos and shit like that. He don't be telling y'all the little details. So I don't know when he pulled this last minute reunion shit or something like that. Was that what it was? And you thought you was about to get another continuation? No, did you even take that motherfucking psych eval yet? Because when T from TV read the documents, and I'm gonna put her link in the comment section, in the description box here, and pin it in the comment section so y'all can go over there and get the actual documents. Okay, I got the documents for Benny, but I don't have the documents for Martell shit. But this motherfucker tried to submit a continuation because he had to go out of town for work. The judge denied it. His ex-wife rebutted it. Like, no, he ain't got no motherfucking reason not to have his skinhead ass in this motherfucking court. So get in here. So this motherfucker, of course, he gonna do what the fuck he wanna do. Because he Martell motherfucking Holt. Didn't even bother showing. But his attorney showed. I wish the judge would have sanctioned his picklehead ass and for not coming to that damn court case. Because this one is not, this one, like he tried to rebut this one, a countersue her on this one. Because you know he kept on trying to bring her to court for the fucking full custody, knowing he didn't want them damn kids. Just to terrorize her damn ass, but I damn grass. So then, after he became so unhinged and got that legal case on him, the criminal case, y'all remember that? Criminal case? Then the ex-wife said, oh no, bitch. Now I want full custody because you are very much so unhinged, especially after he pled guilty to the shit the first time, then wanted to appeal his own plea. I digress. Pissed off. I ain't talked about Martell in a while. So they proceeded with court last week and he didn't come. His attorney was there. His ex-wife and stuff like that. They were all there. She had her support team. And then yesterday, the judge came the hammer down. This is a very good step forward for the ex-wife and the children because y'all know, to me, he was horrible to those kids. He played mind games with them, all of the things. And I am so damn happy that they will only really have to see him every other weekend. That's even if he do that. Because that's what the judge ordered. The new order, the guardian ad litem was there. And he didn't lose custody. He still have child, my God. He still have joint custody. They still have joint custody, but his ex-wife has full physical custody. Like in Shaboing Boing and Marquez case, they have joint custody. And that, I think, well, they don't have that in LeBergnum case though, because they got the week on, week off in LeBerg and Dusty's. But so now she has full physical custody of the kids, and then he get the kids every other weekend from Friday to the following Sunday, which means because after Friday, the Sunday is the next week. Sunday is the beginning day of the week. So he only can get them from Friday to Sunday every other week. And like I said, I'm happy about that piece. But I actually think that this is some bullshit. And this judge is on some bullshit because to me, he got exactly what the fuck he wanted. He can't terrorize her no more because he knows she'll put them damn papers in his life. So now he don't need, and he see he can't get no money for them. So now he don't even want the fucking kids. He didn't want them to begin with. And when I say don't want them, he don't want them full time like he was trying to claim. Like he was such a father of the motherfucking year. Daddy's home. But I think he just got all kind of like scotch-free. The judge should have ordered that motherfucker to pay some child support. Since you didn't come to court because you had work, bitch, pay for your motherfucking kids. Contribute to your motherfucking kids because he still have joint thing where they still have to talk about, he still have a say-so, 50-50 say-so in decision-making and shit like that. The kids still can't be on TV or social media that's for profit or anything like that, even if the profit is for them. That's fucked up. In my opinion. Like he's skating his ass scotch free. So now they can't even go on social media to make no money because they could have them a whole little reality show. But they can't go on and make no money from their own selves. And he ain't gotta pay no fucking child support. So Melanie just gotta pay her whole motherfucking damn her whole like she gotta pay for all the fucking expenses. She even have to pay for the guardian ad litem. I don't think that shit is fucking fair. And again, he didn't lose the full custody, the physical custody, the week on, week off. He didn't lose that privilege because he didn't come to court. He lost it because it was the recommendation from the guardian ad litem. That situation is not in the best interest of the kids any fucking longer. No child support. Kids maybe every other weekend. But y'all know what? I know Slaw happy than a motherfucker, but that damn smile ain't gonna last fucking long because guess what? Now that he don't have to deal with his own cheering, he ain't got no gain from him. He not gonna be, dealing with him every other weekend. That motherfucker about to run rogue. He might have some more kids. He might be out here making some more kids. He ain't about to be studying Slaw because now he ain't got the responsibility of them kids every other week. He ain't gonna be trying to think about her motherfucking ass because she's another bill. And don't mess with Bill. Yeah, his little Bill looking ass. I think they should have disputed that shit about the damn child support and shit like that. If he's still gonna have decision making like he had before, he need to be contributing financially. All the financial responsibility shouldn't be on me if I'm getting full physical fucking custody. The fuck? We got 4 kids. And the ex-wife might not want the motherfucking money, but them kids need it. It's money that goes to them, contributes to them. So he needs to be paying for them because he had all 4 of them. So I don't like this. I'm happy about the custody piece, the full custody, physical custody change, but all that other stuff, no, he getting away scotch free, and he ain't gonna do nothing but go out and make some more motherfucking damn kids. He ain't about to do shit but go out and make some more broken motherfucking homes. Coleslaw, you better put a leash on his bitch ass. Mm-hmm. So y'all, let's move on. Again, if y'all want to see the full documents for that case, y'all got to go over to T from TV. Okay. This motherfucker right here. You know what? I think Carol Merrill might have broke it down too. She said she was gonna get some more details about the case. So I think she might have got a hold of the paperwork too. So y'all go to either one of them, okay? But shut up when take talk, you fat bitch. You lost too. You a loser too. Don't talk about my case or I'm going to talk about yours. That you in with me? Hell yeah, I'm going to talk about that too. Benny, you ain't about to be talking about shit with me when it comes to me. I'm going to talk about it today, tomorrow, and every other motherfucking day after, you fat bitch. You blind motherfucker. Child, let's get into this mess, okay? Because Benny, why did you even do this? Because y'all know that he was suing the former queen, the reality star. She's still the queen of the reality TV. In my opinion, just so his stalking ass could look at her. Okay. Now let's take a gander at some of his court documents, okay? Because y'all know I got them all day. I read the one. Y'all gonna have to I'll put that video in the link too, where y'all can see the original petition he submitted and stuff like that. And then y'all know that they had court one time, and the former reality star did not show to court. So I'm like, what the hell? Because I didn't see the court case in the docket. So I was like, did he do something? Because you know they motherfuckers be hacking and shit like that. They always accusing other people of hacking, but you know, I heard they was the hackers, but I digress. But the judge, you know, as soon as they got wind of it, the attorney, I think her name is Kentisha, she filed a motion to set aside the default judgment and to reschedule the hearing because she didn't get it electronically. But it looks like they did mail it out. The judge set the hearing, I think, in May. And then let me take a look at it. And I'll share my screen and show you Mo's. Go here. See, like it wasn't on this page here. Like it wasn't on this page. Like how all the stuff here, like it wasn't on here where the, you know, case or nothing like that. It just had the order. And the thing was set back in like here it'll show like what a person you know where they order sent the, you know, set a hearing, it'll say like set hearing and stuff like that. Like it says right here, like order setting hearing, it will say all of that stuff, but it didn't. So I was like, what the hell, did he do something? But it did show it when I showed go back. I gotta do this because I don't want to show nobody's address. And then let's see here. Share my screen. So here it shows it on this case action summary. It showed here. Let me blow this up. It showed, where was it? Filed a case. It was served. And then sheriff served on April 30th. So y'all go and watch that video. This is when the attorney came on and they responded. And then this is when it was set for bench trial on 5/28. It was set for bench trial here. And then for August 18th. But then it didn't, the notice wasn't sent out until like damn near a month later. And then, but they didn't get it. It went to Benny and it went to the attorney, but it didn't go to the former reality star at all. So that was that. And then so he got a judgment. See, this happened August 18th. Then he get a judgment here in the beginning of September, default judgment because there were no shows. And then we have here where they, you know, submitted for the motion to set aside the default judgment. So They set, let me go to, when was this? On the 2nd, that's when the attorney filed the motion to set aside the default judgment. A hearing was set for it, but Benny rebutted that. Let me see. Motion to set aside his objection. I'll go to that, to the objection, so that I'll read that because there is a discrepancy in there. So let's read that. 1 second. Let me pull it up. What date was that? Okay, let's read what he put in here. Okay, this is it. So let's take a gander at this real quick. Don't mess with Bill. Okay, so this is Anthony Lofties versus Melody Cherie Rogers. And is plaintiff opposition to defendant's motion to set aside default judgment comes now. The plaintiff, Anthony Lofties, and respectfully submits this opposition to defendant Melody Cherie Holt Rogers' motion to set aside default judgment, and as grounds therefore states as follows. 1, background. On May 28, 2025 at 9:27 a.m., the court entered a trial setting on Alicourt, reflecting that a bench trial was scheduled for August 18th at 9 a.m. See Alicourt docket entry May 28, 2025. Defendant's counsel remained actively engaged in this matter thereafter. Filing a response on May 27, 2025, defendant and her counsel therefore had clearly 3 months to review the docket and prepare for trial. Neither defendant nor her counsel appeared on August 18th, 2025, and a default judgment was accordingly entered against her. Legal standard. Under Rule 55C of Alabama Rules of Civil Procedures, a court may set aside an entry of default for good cause shown and may set aside a default judgment under Rule 60B only upon a showing of mistake, inadvertence, surprise, or excusable neglect. The burden rests with the moving party to establish just grounds. See, and he gave a case study. Argument. Defendant had adequate notice of the trial date. The record is clear that the trial date was entered on Alicourt on May 28, 2025. Alicourt is the official court filing and notice system for Alabama. Counsel had an affirmative duty to monitor the docket. The assertion that defendant's counsel did not receive separate notice is insufficient, as courts consistently hold the parties are charged with knowledge of entries posted on the docket. See Ex parte Family Dollar Stores of Alabama. He gave another case study. B, defendant's neglect is not excusable. Defendant's counsel had nearly 3 months from the date of the docket entry until trial to review the docket and prepare. Filing documents in the interim demonstrates counsel's active participation in the case. The failure to check the docket does not constitute excusable neglect under Rule 60B. Plaintiff will suffer prejudice if default judgment is set aside. Contrary to defendant's assertion, plaintiff will suffer prejudice if the default judgment is set aside. Plaintiff appeared on August 18th with his manager / co-worker. Y'all keep this in mind. Manager / co-worker prepared to testify regarding material facts. Plaintiff expended time, resources, and and effort to prepare for trial, and that opportunity has been lost. Requiring plaintiff to relitigate the matters, imposing undue burden, expense, and delay, which constitutes prejudice. And he give a case study. Recognizing prejudice as a factor in evaluating motions to set aside default. And in conclusion, defendant has failed to establish excusable neglect or other grounds warranting relief under Alabama Civil Rule Procedure 55C or 60B. The default judgment was properly entered after defendant failed to appear at a duly noticed trial. Plaintiff respectfully requests that this court deny defendant's motion to set aside default judgment. So he has some exhibits. So let me put this overlay on here because it's a piece I don't want to show. His address and phone number. Okay, I'm gonna take the overlay off. So here he did the judge the order, proposed order. This matter is before the court. This is his proposed order. This matter is before the court on defendant Melanie Cherie Holt Rogers' motion to set aside default judgment upon consideration of the motion, the plaintiff's opposition, the record, and the applicable law. The court finds that defendant has failed to demonstrate good cause or excusable neglect warranting relief under Rule 55C or Rule 60B of the Alabama Rules of Civil Procedure. Accordingly, it is ordered, a judge decreed that defendant's motion to set aside default judgment is hereby denied. The default judgment entered on August 18, 2025 shall remain in full force and effect. Now, this is just what he proposed the outcome, the order be. Okay, this is his proposed. Now, let me go to some of his exhibits. Let me see first. I gotta see what else he had on here. Okay, he do the certificate of service. And then here's his exhibit. So let me move him out of the way. His exhibit A was the Alicourt log. Page 3, 4 is the bench trial set. Page 4, notice sent to plaintiff and defendant. 7, plaintiff's reply to defendant's answer and affirmative defense. It's here. Defendant posts on social media about Judge Linda Coates' ruling and why it took so long. He submitted this. Melody Cherie, he has a, to be honest, after a court date, y'all see in a day or two, there's a ruling. It doesn't show it till September 2nd. Even that was strange for my attorney and I. So it has response, blogger harassment. Then he has Melody Cherie Rogers. Why would it be 2 weeks for a judgment to be entered? It doesn't take that long, LOL. Then he has this post. Let me see if I can. No, I can't rotate it. Okay. So y'all just go. It doesn't take that long. Look how quickly y'all see orders and rulings in every case. LOL. Exhibit C, defendant's post on her platform that has following of 640,000 plus, calling out plaintiff and exposing the judge to the world. The judge is already exposed to the world, you idiot. You didn't expose the judge to the world when you was popping your shit about the default judgment. Plaintiff never brought the judgment to social media, only the defendant. Well, he might have a little. She didn't bring it either because I know I brought it. This is screenshots of her stories. What account is this under? Are you supposed to be on her stuff? Stalking. Anthony, you might want to shut up and keep my name out your mouth, hotcakes. My countersuit is already looked ready, good over. Already looked really good over. Don't make the number higher. We do have a new hearing coming up shortly. Since the courts failed to inform me and my attorney of the court date, check the docs, boo. It's been filed. Now, I'll see you at the next hearing. Worry about that 11,000 lawsuits you filed and still have pending. Mind your business. That's right. You have none except running behind folks you wish you could be. Exhibit D. Defendant legal counsel was actively a part of the case to know the date. Let the record show. Email thread between plaintiff and defendant legal counsel confirming she received the response. Defendant legal counsel never got back to the plaintiff. I guess this is Anthony Lofty's plaintiff opposition to defendant's affirmative defense of lashes. He sent it to Kentisha Matthews. This is the attorney. Good morning. I am in receipt of your response. I will review it and get back to you. Thank you. What did he send her? Oh, a PDF file. When was this? June 30th. June 30th. Good morning. I am receipt. Okay. Exhibit E. By defendant exposing the judgment, caused more videos to be created about the plaintiff. I seen it in Alicourt. He has this content creator on here. I don't know her name. Melanie Cherie calls out blogger Anthony L. and reveals her ex-husband punched her. In his video, I'll give commentary on Melanie Cherie calling out blogger Anthony Lofty's and reveals that her ex-husband has allegedly been violent with her. How this content was made. Melanie Cherie Rogers responds to blogger harassment. I don't know who channel this is. Thank you so much. Now he got me as a damn exhibit. Breaking news. Mel gives her thoughts on shocking update in lawsuit with Benny's judgment. Not him owning Benny. Exhibit F. Let the record show plaintiff had manager / co-worker in Huntsville, Alabama at the courthouse ready to testify. I guess the manager's name is Felix. Monday, August 11th at 11:52 a.m. Hey, don't forget we go to Huntsville, Alabama next Monday. At 4:04 p.m., I guess Felix replied, I got it, buddy. Now, why is he calling you buddy? If that's why you call the defendant Miss Buddy. Sunday, August 17th at 8:20 p.m. Hey, don't forget, you have to be at my place at 6:30, I guess, a.m. We have to get on the road by 6:30 a.m. And he gives his address. I guess Felix said, yes, sir. It's on the schedule. Thank for giving me the time. What? Monday, August 18th, the day of the court hearing at 6:12 a.m. Hey, buddy, I'm here. No, I'm on my way. And Buddy says, okay, coming down. The court hearing that he said was at 9 a.m. So Monday, August 18th, the day of the court hearing at 10:24 a.m. He says, how long will you be? Wait, this is. How long will you be? My car just did something weird, and I think we need to get on the road. Buddy says, okay. Now I'm confused because why is now Felix information or messages are on this side of the screen and not on this side of the screen where it was? Y'all see that? Why is Felix's messages now over here in dark and not over on the side in like this, like the other messages of his is? You see that? Hey, sir. Yes, sir. This is clearly Benny over on this side, on the right side, and the left side is presumed to be Felix. I told y'all I was gonna find some damn discrepancies, but I just found this one right here. But this is supposed to be Felix again, correct? This is supposed to be Felix. How long will you be? My car just did something weird, and I think we need to get on the road. This is just an hour and barely a half into the court hearing. The hearing was set at 9. Okay. So I don't know if he just said okay back to him. But this again, this is on the side where Felix was supposed to be talking, not Benny. But this is another thing that this is the main thing that I brought up with the discrepancy here is that how the fuck you said here, let the record show plaintiff had manager / co-worker in Huntsville, Alabama at the courthouse ready to testify. From these messages, it appears he was just giving you a ride because here he says, how long will you be? My car just did something weird, and I think we need to get on the road. Per the messages up here, he's taking you to Huntsville. He's there. I'm here. Hey, buddy, I'm here. So if he was there to testify, why the fuck would he have been sitting in a damn car in Alabama in fucking August? He would have been in the courtroom with you ready to testify, not sitting out in the motherfucking car. Because if the defendant or the attorney was not there, it was no need for him to be in the car already. He hadn't given any testimony because they weren't there. So no testimony would have been presented because they weren't there. So why was he out in the car? And even if you were giving your testimony without them being there, why would he be in the car? Because after you say what you say, you had your witness say what he got to say, put that on the record, and then both of y'all will be leaving together since the defendants weren't there. This what we mean by you always putting some motherfucking bullshit together. Piecing shit together. But I digress. Let me get back to the docket because what was the update from yesterday? Let's do that. Okay. share this screen here. So we got here a subpoena. Make sure nobody's address is shown before I show this. I'll just share this part. So this is a subpoena order to appear, issued at the request of the defendant. Appear at trial, produce records or documents. See attached. So here is the person that was being subpoenaed, YAPA Apartment Living Program Inc. DBA Project Transition. Okay. You may contact Kentisha. So this is the attorney they're requesting. The defendant side is requesting that Anthony's employer, ex-employer, appear. You are ordered to appear to give testimony before the court or by deposition, and or produce and permit inspection and copying of books, documents, or tangible things, and or permits inspections or premises as stated below until otherwise excused. Failure to obey the subpoena may be deemed a contempt of court from which the subpoena was issued. Okay, now let's get into the subpoena details. Okay. Exhibit A. Please provide, this is for Anthony Lofty's and Melanie Cherie Holt Rogers case number. And then it has Exhibit A. This must have been what they submitted to the court. They didn't put the actual documents in here because I'm quite sure they're probably redacted. Please provide all employment records, whether paper or electronic, related to A, Anthony Lofty's date of birth, SSN. They don't get a full thing, so said records should include, but not be limited to, entire personnel file, including any disciplinary reviews and or reports, and all inter-office emails, instant messages, group chats, or similar messaging systems sent or received by Anthony Lofty's containing content outside his scope of employment, and documentation of termination of employment. Please provide an estimate for the cost of production of the above listed records prior to production. If you have any questions, please contact me, and they get an attorney name and phone number. Yeah. Okay, now let's get to this order. Okay. Final order. This matter came before the court on October 20th, 2025, which was yesterday, for a final hearing. The plaintiff was present pro se, not the team of me lawyers, okay? The lawyers included a team of me, which is Benny. The defendant was present and represented by Kentisha Matthews, Esquire. Based upon careful consideration of the sworn testimony and other evidence presented, the court finds in favor of the defendant on the claims of the plaintiff. All other claims not addressed herein are denied. Each party to bear their own costs. Done this 20th day of October 2025 from Linda Coates. So, Benny, what you got to say about this? Because you were talking a lot of shit, Benny. Let's read this from 2 weeks ago. This community post. Interesting how she claims I'm following after people I wish I could be, while her own circle is consistently following her lead. And it hasn't gone unnoticed that whenever your former coworker releases something, you manage to release something strikingly similar. That doesn't sell nowhere near the amount your former. You know where I'm going with that. By the way, when the winter event takes place, would those individuals also be considered as running behind you? Benny, what the hell does this mean? One month ago, stand on truth. I recognize you are attempting to stall for time, but delays will not change the fact or alter the truth. I manage my own schedule and remain fully prepared to move forward. Plus, I got to see my devil. Okay? 1 month ago, me sitting back watching karma play out. Cheers, batch. Watch how God bless you right in front of your enemies. Vindicated. And y'all know this was all where the stuff happened when the shit happened in the chat. Remember all that? This is all from there. Oh, yes, he was rejoicing. He was rejoicing, okay? But again, my hands are clean. So you vindicated where, sir? Well, let's move on. Let the record show y'all got played. What record? This court record? Don't get mad, glad, get glad. Who's mad? This, I guess he was celebrating Stormy birthday, child, looking like a complete damn fool. How do you call someone poor when you need help moving from your apartment to the one across the street? You're over 40, I think. Remember, I'm a boss who makes my own schedule. Why? Per your termination? You once thought that was sexy. Now get back to your retail job and stock those shelves. That motherfucker be talking big shit. Let me get back to this poor Florida vacation currently on and prepare to go to Japan. Who you going to Japan with, Aunt Ann? They say wisdom comes with age. I guess it skipped you. Be blessed, my brother. Tell him to pay for an attorney. He's poor. LOL. It's money grab and he will lose. Well, seems like he was right. Where is it going? Nowhere if you keep coming for my phone. Laughing face. How work going? Oh, this his text messages with Jay Taylor? How work going? Man, it's okay. About to leave and go home. Why? Is this Benny and this Jay Taylor? I make my own schedule. Almost done. Why is that to why? Okay, a boss. That's sexy. Oh, that's what he meant by he said that he thought it was sexy. What you doing? Cleaning so I can start packing up my place. You coming to help? Crickets, LOL. Drop Benny said he ain't helping your ass do shit. Drop some dick. Benny, what is this? 4 months ago, I refuse to settle for $4,500, an NDA, and a gag order not to talk about you. Even if you offer me $25,000 or $50,000, my answer remains no. I'm taking this all the way. All the way where, motherfucker? Question. WHENTAYTALK. Hi, Benny. Do you regret refusing the said settlement? Said invisible settlement? You shut up, WHENTAYTALK, you fat bitch. I'ma settle your ass soon. Let's set the record straight. Benny is upset, quite upset. He's in quite the pickle, or released from the pickle. He turned down $4,500 NDA. And what do you need an NDA for? And a gag order not to talk about you. He said he wouldn't accept it even if it was $25,000 or $50,000. His answer remains no. Okay. The judge told him no. Final order denied. Court finds in favor of the defendant. Rogers, Melody, Cherie Holt. Benny, any comments? Just asking for a friend. Okay. All right. So that's all I got for y'all moles. All right. Y'all make sure y'all like this video, subscribe to this channel, and click the bell notification so you know every time I upload a new video. And I'll talk to y'all moles later. Bye.
Oh my gosh. Ew.
Hold on, 20.
Huh?
Hold on, 20. Hold on.
What'd you say?
I said, hold on, 20. Hold on, please.